morning, Counsel.
Good morning, Your Honor. Congratulations.
Thank you.
May it please the Court, William Helmkin with Judith Eddington for the appellant, Global Inc. Global Inc. is a vendor that sells fuel to...
Why don't you just...
Oh, I'm sorry. I saw the green light go on.
No, you're right.
Well,
but it
let's
just
start
seems to
over.
me-
We're
Yeah, we
going
can start
to
over.
give you a full 15 minutes. Yes, sir.
Global Inc. is a vendor of fuel. It sells to my client, Highline. Highline expends the fuel in what we consider to be an exempt manner. However, because under the statute, the way it's created, only the vendor gets to file the appeal. But we're really focused upon Highline. In 1988, this court issued an opinion to the House of Representatives with respect to the convention center surcharge and whether or not the legislature could charge a lower rate for the rental of automobiles in Boston to residents of Boston.
But in that case, I mean, the elephant in the room was it was incredibly discriminatory against anybody who didn't live in Boston.
And we do not...
And you don't have that here.
And we've said there's no constitutional claim here. But in your opinion, you said before we get to whether or not there's a burden on interstate foreign commerce, we first have to determine whether or not the Commerce Clause is implicated. And so the first part of the test was, are the cars rented to tourists? And the court assumed it was.
But if you... Implication of the Commerce Clause, and I would take it that it would be clear that if Massachusetts were to impose a higher tax on a company that provided these same services that was going from Providence to Martha's Vineyard or something like that, you know, there would be a problem. But the fact that it implicates the Commerce Clause doesn't mean necessarily that that's what the legislature had in mind when they're saying engaging in foreign...
Absolutely, and we agree with that. And the government said this is a simple case. Is Highline engaged in interstate commerce? And to determine that, we look to the Commerce Clause jurisprudence, where courts have said certain activities constitute engaged in interstate or foreign commerce. And that was the first part of the court's analysis. And then the rest of the court's analysis we set aside because we're not making a constitutional claim. Again, the court assumed in that case that a lot of the automobiles were rented to tourists. And tourism is very important, and tourism is commerce. In our case, we brought experts in, the head of the tourist industry in Cape Cod and on Nantucket, and we brought in studies by the company, and everybody agrees. Tourism for Cape Cod and the islands is essential. It's one of the main industries. And the Appellate Tax Board found that because we have a lot of tourists, I think 70% of the people that go to Nantucket are foreigners. And foreigners meaning...
Out of state.
Out of state or country.
Could I ask you this, though? I accept that. But why is it, I guess what I'm, if I just look at the language of 6.0, engaging in foreign or interstate commerce, why is it that your Highline is any different than a person or a company in Nantucket that has, in the summer, water skiing, has boats. You can rent the boat and go water skiing. Tons of tourists on Nantucket in the summer, as you rely on.
Yes.
Why is that seller of the water skiing services or renter of the water skiing boats who needs fuel, why is that person or that entity any different than Highline?
They may not be.
But you argue, or you seem to say, well, don't worry, because we provide an essential service. But that isn't part of 6.0, whether it's an essential service.
I understand that. Again, we were trying to establish, it's beyond doubt, we're engaged in interstate and foreign commerce. We're part of national transportation system. We're regulated by the Coast Guard. We're regulated by Homeland Security.
We're focusing here on what the legislature meant by those words, correct?
Yes.
So is it your view that the legislature meant to include any vessel that's engaged in the constitutional definition of foreign and interstate commerce?
I think, and as you know, Massachusetts is very little legislative history, but if you look at 6.0, there's 3 exemptions in 6.0. There's one for builders of Massachusetts boat builders of 50-ton burden or more, meant to benefit that industry in Massachusetts. There's an exemption for commercial fishermen, meant to benefit local fishermen. And then there's the exemption we're talking about, which I think they were thinking about commercial operations. However, the state of Maine faces the same problem, and 2 cases, Brent, which we cite, and the Supreme Court in Brent basically qualifying what the Superior Court said. And that was a case, and I think it's similar to what you suggest, Justice. It was recreational. We're going to take boats from Maine, we're going to go out a couple of miles and do some whale watching and then come back. And that's exactly, I think, what he's talking about, a fishing boat, recreational fishing boat. But Maine was smart. Maine said, in its definition, and again, not getting to the constitutional, but its definition of the exemption, this exemption does not apply to situations where a vessel leaves the port, goes out beyond 3 miles, does whatever it wants to do, and comes back to the port. And the Maine Supreme Court said, but for that legislative history, but for the regulation defining it, we would have to conclude, under Commerce Clause jurisprudence, that they were engaged in interstate.
Okay, so you're telling me that the legislature, when it used this language, meant to include, for instance, lobstermen who may be selling their lobsters in interstate commerce, that their fuel is also protected?
Well, they would probably qualify as being commercial fishermen. I think the legislature, when I look at that...
Is there a separate exemption for fuel used in commercial fishing?
Yeah, there's 3 under 6.0. There's 3
right,
parts.
But 6.0 speaks about only to vessels engaged in foreign interstate commerce and sales of vessels used directly and exclusively in commercial fishing. That's only sales of vessels. It doesn't
I
speak.
understand.
It's the same provision that we're speaking of here, which would apply to fuel for those vessels. And you're saying that they meant to include all commercial fishermen because they're in interstate commerce?
I have
all
no idea
recreation because they're in interstate commerce?
I have no idea what they actually intended, but I look at the structure of that exemption. I think they were trying to promote local industry. But in terms of the slippery slope, I think all you have to do is issue regulations. Now, by way of example, this court has
regulations can't be contrary to the statute.
You can change the statute, or you can explain the regulation. This court has been very good to local manufacturers, expanding the definition of what constitutes the manufacturer, and in turn, the Department of Revenue has issued regulations explaining it. And so I don't think the slippery slope isn't that slippery. And again,
But you mean if the Department of Revenue issued a regulation saying, we interpret Section 6.0 to exempt only those vessels that are carrying passengers that are actually going out of state, coming from out of state and into Massachusetts, and stopping here and going somewhere else, or starting here and going somewhere else. You'd say that would be okay by regulation?
I don't want to pass on that because it probably is inconsistent with some of my other clients. But again, in this particular case, we're talking about the final leg on interstate and foreign commerce, and that concept of multi-legs being in commerce, again, is an old Commerce Clause concept. Doesn't go to the constitutionality of it, just how you view the final leg as being interstate commerce, and local activities may not qualify. So I'm suggesting that if there is a slippery slope, it may be cured by legislation, it may be cured by regulation, it may be cured by viewing those activities as local in nature and not part of interstate or foreign commerce. And so I think it's clear.
But the issue is not, can the legislature fix it? Of course the legislature can fix
Yes.
it. The issue is we need to discern what the legislative intent was in the use of this language. And you're suggesting that that the legislature here intended that language to be as broad as the Supreme Court has interpreted the Commerce Clause for purposes of determining the extent of congressional action. I mean, that appears to be what you're asking us to do.
I believe in a broad interpretation of the Commerce Clause and what constitutes commerce.
But that's the question Justice Gantz is asking, not how broad the Commerce Clause is, but you're saying that's what our legislature meant to incorporate by the use of this phrase. Is that right?
I think there's a distinction between activities that affect interstate foreign commerce and activities that constitute engaged in it. For instance, a lot of people come to, and will be coming shortly to Massachusetts, to see playoff games. They come here for that purpose. That affects local commerce. Is that engaged in interstate commerce? Absolutely not. But it affects, the weather affects interstate foreign commerce, but doesn't constitute engaging in that activity.
Is there legislative history that tells us what our legislature thought about this provision?
No, there is not, and that's very typical in Massachusetts. There's very few legislative history, but you look at it, and again, I believe that the provision in 6.0 that talked about benefiting local builders of boats 50, I think this court acknowledged that that was to encourage local boat builders. The court struck it down as facially unconstitutional, but then expanded the exemption to foreign builders. In the manufacturing context, this court assumed that the legislature wanted to encourage local businesses, either existing here or bringing other businesses into Massachusetts, so gave an expansive interpretation to it. The other thing is...
But if that's right, then wouldn't it be the case that the legislature was mindful that if you were involved in interstate or foreign commerce, you could gas up either in Massachusetts or in Rhode Island, and in order to not to discourage you from gassing up in Massachusetts, we're going to basically exempt you from the tax on that. Why is that not a more sensible understanding as to what the legislature wished to intend here?
You have to keep in mind that when this statute was enacted in 1966 as temporary measure, made permanent in 1967, the taxation of instrumentalities and interstate commerce, foreign commerce, was prohibited.
Right, under 6A.
Yeah, and at that time, the jurisdictional waters of Massachusetts was 3 miles out. Once you went beyond 3 miles, you had no right to tax anybody. And so I look at it that when they said interstate foreign commerce, they're talking about boats engaged in commerce that travel beyond the 3 mile limit. And then in 1986, in U.S. versus Maine, Massachusetts tried to take jurisdiction all in the entire Nantucket Sound. And the U.S. court said, no, you don't, guys. You get 3 miles out, and that's all you get. After 3 miles, it's the high seas. And the high seas at that point would have defined both federal and international waters. Now, in 1988, there was a presidential proclamation that extended the 3 mile limitation to 12 miles for certain purposes. For wartime, for national security, and certain shipping. There's a regulation by the Coast Guard, and we cited in our brief, that said that presidential proclamation did not extend to state activities, for instance, taxation. So the states And I guess the government was arguing, we're not in international waters beyond 3 miles, because we don't go out beyond 12. But the fact of the matter is, it's still a 3-mile limit, and from 3 to 12 miles out, it's federal waters for certain purposes, but for most purposes, it's international waters. So if you get the fact that these people started their journey in London or in Ohio, and this is the last leg, let's consider it, let's forget about that. They got on a boat in Hyannis or New Bedford or wherever, and they went out more than 3 miles in commerce in international waters. And if you go back to the leading case of Lord back in 1880, it said when you have a boat that left a port in California, went out to the high seas and back to another port in California, that was international commerce, because when you were out beyond 3 miles, you were in the shipping lanes of other nations, and even though you were not trading with other nations, you were engaged in commerce with international. And like everybody else, I extended beyond my time limitation. I thank you.
Thank you, Counsel.
Good morning, Your Honors. May it please the Court, Jennifer Grace Miller from the Attorney General's Office.
Attorney Miller, I want to ask you just two hypotheticals, because I'm trying to understand what happens in these taxing situations. If there were a cruise ship, a foreign cruise ship that landed in, I guess, Boston, and had booked a tour around different ports around the world, and part of that tour involved the rental of this ship by the tour company for whatever the capacity was. You know, nobody else could get on it. It was a rental. It was like a private rental of this ship, and they bought the fuel. Would that be, at least for that trip, would that be entitled to that purchase of fuel be entitled to the exemption? The other one, the other hypothetical is, if the ship got stranded 3 miles out because it ran out of fuel, and somebody came out to pump more fuel into it, would that be taxed if the refueling occurred in international waters?
Let me take the first first. I would say no to your first, because the tourists, if you will, who have arrived on that passenger cruise ship have arrived in Boston, much like tourists would arrive in Boston by plane or by car or however else tourists arrive in Boston. So if the passengers are coming to Boston on that cruise ship, they get off the cruise ship, they get on this ship.
As part of the international tour package.
Well, if they get on this ship, it would be difficult, because, Your Honor, if what they expected when they boarded this particular ship and the purpose of the rental was to go from one point in Boston to another point in Boston, then the fuel for this particular, in Boston, forgive me, another point in Massachusetts, then the fuel for this particular ship would not be exempt.
I mean, if Highline contracts with Carnival Lines,
Right.
Highline still isn't going to be exempt, because even though these people are from all over,
Exactly.
it's just moving them in Massachusetts.
Exactly right.
It's just a purchase of a local trip.
Exactly. When those tourists come to the Heinlein ship, they expect and purchase transportation within Massachusetts.
What about refueling in the high seas?
Now, the only question I had about that, Your Honor, was which ship is being refueled?
Well, the
Is
one
it
that's this one,
Highline.
his ship.
It's the Heinlein ship. If it's the Heinlein ship and it's being refueled in international waters, it doesn't make any difference, Your Honor.
It does or does not?
It does not. It should not make any difference.
Could I ask you just about that? Because Mr. Hampton finished with the Lord case, and the language in the Lord case says, you know, when you go from San Diego to San Francisco and you go beyond the 3-mile line, you are engaged, and it uses the words, engaging in foreign commerce, which is the same words that are in our statute. So how come it doesn't apply?
Right. Well, and forgive me, Your Honor, I'm having trouble this morning for some reason with my voice, but it's different because the Lord case is a Commerce Clause case.
Because it's applying, the federal government is seeking to regulate.
Exactly right.
These
It's
are the
about
boundaries of the Commerce Clause, the positive side, not the dormant side.
Exactly. It's about the scope of federal power Federal power under the Commerce Clause is broad, and the test that is applied is whether or not, in this case, foreign commerce was affected. It's very different from whether or not the term of art that's developed over time, and of course the Lord case is an older case, and the term of art has become more clear over time. But we now know, and certainly the legislature would have known in 1968 when it adopted this particular phraseology, that the term engaged in commerce is a term of art. And it is not equivalent with the usual Commerce Clause test of affecting commerce. Engaged in commerce means something narrower and more concrete. As the Supreme Court put it in the Circuit City case, it means actually engaged in the flow of commerce, actually moving goods from one place to another, from one state to another. So what you have to have when you engage in interstate or foreign commerce is commerce that occurs in two jurisdictions. There must be at least two states involved, and there must be at least two countries involved. The actual transaction, the actual commerce, must engage, if you will, two separate jurisdictions. And that did not happen here. Highline sold tickets from one point in Massachusetts to another point in Massachusetts. When the individuals purchased their tickets to get on the Highline, they were not purchasing transportation between jurisdictions. They weren't purchasing transportation to a state or to a foreign country. They were purchasing tickets to go from one spot in Massachusetts to another spot in Massachusetts. Therefore, the passengers on the Highline, the vessels on the Highline were not engaged in interstate or foreign commerce.
And when you say it's a term of art, in which field of art?
Well, you're right, Your Honor, in the sense that the phrase has developed. There's always a Commerce Clause issue in the background, if you will, Your Honor, because that's the most natural place for people where people generally talk about interstate commerce. But the Supreme Court has made clear that when legislatures choose different modifiers with respect to the word interstate commerce, they mean different things. Now, of course, with respect to the Circuit City case, we weren't talking about moving goods necessarily. We were talking about whether or not you could have arbitration, when you're encouraging federal arbitration for cases. And so that the legislature used language, interstate commerce, in that context, which might naturally lead you to think about Commerce Clause cases.
Okay, but you're saying, I think, more than that. I thought you're saying that when the legislature, when whoever drafted this used the term engaged in commerce, that person knew what he or she meant, and what he or she meant relates to the understanding of that term somewhere. I'm asking where would we go to say, aha, this term is commonly used and means what you say it means?
I think, forgive me, Your Honor, the first place you'd look is at the plain language. That's the first place the Supreme Court looked as well. We'll start there.
It's not that plain.
Well, but general words like involving or affecting
Okay, are certainly broader, I
are
understand.
certainly broader. So when you use the word engaged, that's obviously narrower. You obviously mean something when you choose that particular word. And so the court in Circuit City essentially rejected the notion that by consciously choosing that particular word, then the legislature was essentially rejecting the use of the term interstate commerce as it's used in Commerce Clause claims having to do with affecting interstate commerce.
Okay, but that's all you're saying. You're not saying that we can go to some literature and see that engaged in commerce has meant between two states or between one state and a foreign nation.
Aside from the history traced by the Supreme Court in Circuit City, aside from that, I'm not aware of any other source.
So is your point that by using the word engage, the legislature inferentially, consciously chose not to use affect or involve, and then you look at, I take it you would say, engage in interstate commerce, the common, once you take out those other two words, suggests in this context that the boats are moving in interstate commerce.
That the boats themselves are moving in interstate commerce. They're actually going from one jurisdiction to another jurisdiction, Your Honor.
And it's just a fortuity that they happen to be going through international waters for a brief period of time.
Right. It's actually not at all clear in this particular case. In fact, the board found that they didn't go into international waters. The only
Or
place they
high
went into
seas.
was the federal waters.
Yeah.
But it is incidental. It's merely incidental.
And I guess I think, well, just to use the Lord case, if we were talking about the extent of Congress's ability to regulate or to legislate, I have trouble thinking that international versus federal waters would make a whole lot of
It
difference.
wouldn't make a whole lot of difference, I would imagine, Your Honor. And also, it should be remembered that things that move in interstate commerce can nonetheless be taxed,
Right.
even under the Commerce Clause. And so the Lord case, for example, stands for the proposition that if the contact with another state is incidental, or contacts on the high seas is
Well,
incidental.
yes, I mean, one sees that in the sort of difference between sales and use taxes. I mean,
Exactly.
in fuel.
But the exemption here is for activity that's in interstate commerce.
In interstate and foreign commerce, yes, Your Honor.
Now, for somebody who is traveling, who has a boat that goes from Provincetown to New York, how do they apply for this rebate? They load up their gas in Provincetown. They're traveling to New York City.
Right.
What's the process by which they actually would get this rebate?
They'd have to seek an abatement from
Well,
the
can't they
vendor.
get something, can't they, I would think that in that situation, doesn't the vendor have earlier applied to the Department of,
Well, I would imagine if they regularly fuel a vessel that does engage in interstate or foreign commerce, that there might be a certificate.
or the vessel may have a certificate
A
and say,
certificate,
you
exactly
can't
right.
tax
Here,
us.
right, exactly, Your Honor.
Okay.
But saying that that's not the case, if that's not the case, if there isn't a certificate, say it's an incident, it's a one-off trip to
No,
Provincetown.
I'm referring to there being a daily trip from New York to Provincetown in the summertime,
Right. Well,
which there may be, I don't know.
when there are tax-exempt organizations, generally they have a certificate.
All right, and I guess what you're saying is all they need to do is to say, we go from Provincetown to New York, and therefore we're eligible, as opposed to saying one-third of our passengers come from foreign countries or come from different states.
They shouldn't have to do a survey, that's right, Your Honor. One just last brief note. One of the other reasons that we know that this particular exemption should be construed narrowly is because exemptions are generally construed narrowly. And if, in fact, the construction that Global would give this exemption is adopted, it would broaden this particular exemption. It would suddenly apply to all of those, as the Global says, innumerable boats for hire in and about Massachusetts that do cater to the tourist trade or do go into federal or international waters while they ply their particular trade. And so there's no sound reason for cabining this particular exemption in the manner that Global suggests. If their construction is adopted, it will expand the exemption, and it would expand in the exemption in a manner that the legislature clearly hasn't intended.
Thank you, Counsel.
Thank you, Your Honor.